Thank you so much. We have a real treat today. Typically, MIAS tries to do things in a debate format so as to make it, a less staid presentation. But this first debate is not really debate. It's something that people hear a lot about, which is witness conferencing, or its sexier term, hot tubbing. So we're going to have a demonstration where we're going to have an arbitrator, we're going to have counsel for the state and for the claimant, and we're going to have expert witnesses. And then there's going to be an examination. And again, this is going to be a question of whether the arbitrator should take an inquisitorial approach to quantum. Our arbitrator today, we're very fortunate, particularly for this topic, is Kathleen Paisley. Kathleen Paisley is wonderful for many reasons, but she...
My mother paid him.
Yes. So she is based both here in Miami and in Brussels, where she has really been based for just a few years.
Just a few
years. She has a degree from Yale, but she's really, she has a CPA, and she has a particular expertise in this crossing over between the law and finance and commerce. So I'll let her introduce the panel, but thank you so much. And I would like to remind everyone that counsel have been selected to, have one side. This is a role. You can't ascribe to them the positions they might say as their own. They are acting as counsel, and they're doing their job in how they're arguing. So, Kathleen, thank you so much.
Thank you, Luis. It's an honor to be here. I actually teach damages quantification here a week a year, and many of my students are here. I'd also like to say that from the arbitrator's perspective, this is also not necessarily what I would do if I were actually the arbitrator, but I'm playing a role, and based upon the facts. So what I'd like to this paper, which is some copies of which are at each of your tables, are the facts of the case. You don't have to read it, but if you're bored, feel free. It'll give you a little more background. So I'd like to first introduce my panelists, which I'm really honored to have. And first let me tell you how we're going to do this. We are going to do a mock of witness conferencing for about 45 minutes. The assumption is that there's already been the hearing. The quantification experts have testified in the traditional manner. I, being the pain in the neck arbitrator, says, I know you guys are flying out tomorrow, but I'd really like you to come in one more time, just for an hour, so you don't miss your flights, maybe 40 minutes. We'll see how long we have. And I'd like to ask some questions of the two of you, essentially in a hot tub. So, and also some questions of counsel, which is not so usual in a hot tub, but I found it to be, maybe it's not exactly in the hot tub, but I found it useful also sometimes to have counsel available for questioning at the same time. So that's what we're going to do for about 40 minutes. And then we're going to discuss the proposition that whether or not arbitrators should be more active. There should be a hotter bench. They should be more inquisitorial, to use the civil law term, or what we call the civil law term. I'm not sure it is or not, but whether we should be more active in questioning and taking control, not over the damages phase. I think people make a mistake in saying it's damages. It's quantification. So whether, given the fact that we have this greater margin of maneuver, and particularly in complex damages cases with a strong forward-looking element, they're so nuanced that should the arbitrator take a more active role. And this panel was inspired by the P&ID case, which I won't go into, but let's just say the panel did not take a very active role in that case, and it was not a great thing. So let me introduce my panelists. I'm honored to have as counsel for the claimant, Viren, Say it again.
Mascarenhas.
Mascarenhas. I told him it reminded me of my youth.
She was going to say Macarena. That was a joke that's already been happened.
Who is partner in Milbank Tweed in New York, focused on arbitration. You can assume everyone on the panel is relatively mathy. He does a lot of damages work on his cases and within the firm. And then as the testifying expert, first I'd like to say, in my entire practice, I've never had two female testifying experts before me. It happens quite a bit. I think they testify against each other quite a bit, but I haven't had it. So that's a particular honor today to have two female testifying experts. Carla Chavich is the head of the international arbitration practice in North America for Compass Lexecon. She's based in New York. And she has, I think both of our experts, I noticed, have backgrounds in both economics and finance, which I think is a perfect combination for experts. And they both have been testifying for a long time, which is a big deal for you both. So congratulations on that. And then as counsel for the respondent, we have Tim Rauschning, who is a lawyer at the firm is easy, the Luther firm in Hamburg, where he also focuses on damages. And the interesting thing for this audience, and he'll correct me as to how fluent he is, but he speaks German, English, Spanish, Portuguese, and French. Now that's impressive for a German speaker. And then we have Isabel Kunsman, who is the co-head of Alix Partners International Arbitration Practice, also a testifying expert today and generally, and also has a background in both finance and I always say accounting, finance and economics. So now I'm going to go into role, and we're just going to do, this is not, obviously for those of you who do these cases, this is not exactly how it would go because it's relatively short because we only have an hour till these guys have to get to the airport. So, counsel, experts, thank you so much for accommodating me and being willing to come back, notwithstanding the fact that I know you have places to go and people to see. And what I'd like to do now is, in my mind, there are three particular issues. You did a great job of testifying yesterday. I have a good focus on many things, but I really want to kind of drill down on some of the basics, if you don't mind. So the standard in this case is fair market value, correct? Does everybody agree? Fair market value? Fair market value? Counsel?
That's right. We would argue for full reparations, which in this case we interpret as fair market value.
But the treaty says fair market value, right?
Yes.
Okay. So fair market value. And so the question is, can we agree that for purposes of this case, it's hypothetical, willing buyer, willing seller, without any interference from the state? Is that sort of the standard that the experts applied?
That is the standard that our expert has applied, and we think that's the right standard. It's, of course, a willing buyer and a willing seller in an arm's length transaction, correct. So no interference from the state, which correct. Is what has happened here.
Correct. Okay. So again, I'd like to remind you, as I said yesterday, although you are paid by the parties, I consider you to be the tribunal's expert. You're independent. You're helping me make sure I get this right. So your valuation is $675 US, right? 20.
0, but it's not 20.
20. And both applying the same standard, fair market value, right?
Right.
So help me understand, what is the basis for that huge difference? Why is it your instructions? Why is there a difference of $655 million? Could I just ask you first, and then maybe you can chime in?
Perfect. To respond to that, maybe we can do a short presentation.
Oh, that'd be great. Yes, please.
With that damages.
Yeah, if you could first summarize your position, sure, that'd be great.
So if we go to the next slide, thank you. And as you mentioned, I was instructed to value the claimant's right. In particular, Metal Resources had the right to develop a metal mining land, and I value that right as of the date of valuation in $775 million. And this has been confirmed by the transactions of other pre-operational metal projects, as I will show. As we see in the next slide, the project, the project was a mineral property of metal located in land. The claimant already invested over 50 million in exploring and developing different studies for this property. In particular, it has already a preliminary economic assessment and was working toward a feasibility study by the date of valuation. The preliminary economic assessment, and as we show here, had shown that at the concept level, as a PL level, the project was technically feasible and economically viable, and had found total resources of 100 million ounces of mineral, divided between measured and indicated and inferred resources. A technical report has validated these reports, and can also updating them to develop a production profile based on the information available to him and the previous studies of the mine. As we see in the next slide, I take the technical expert production profile. This technical expert production profile has assumed that 2 million tons will be produced every year. So in total, there will be a production of 20% of the resources that were certified after a 500 million investment. This investment includes investment in infrastructure to be able to sustain this production level. The technical expert explains that even higher production rates and higher production could be obtained with this capex and given the resources available. But I base my DCF on his base case. To price the material, I use a median of different forecasts. As metal is widely traded, as we see on the bottom, there are several forecasts for this mineral and also futures. I take the median of all that information available to price the product. The costs are based on the technical expert and also benchmarked with other mines. The resulting cash flow, I discounted it as the cost of capital. As we show in the next slide, that cost of capital reflects both the risk of pre-operating mineral companies, because it's based on information of pre-operational companies, and it also reflects the risk of operating in land via the country risk premium. This results in a DCF valuation based on this base case of the technical expert, in line with the previous studies, of 675 million. I have also looked into transactions of this type of properties, and as we show in the next slide, I have found over 30 transactions of pre-operational metal mines globally during the last year. I take the median of that implied multiple to value this project. To value the project, one thing that I have to do, and I do, is to penalize the resources by the riskiness. So that is why I only account for 50% of measured and indicated resources and 25% of inferred resources. On the contrary, if they were reserved, they are assumed at 100%. Considering that, I value the project using the multiples in 743 million, just 10% higher than the DCF valuation. And with that, I conclude my summary.
Thank you. I'm not going to let you do this now because I'd like to hear respondents' expert do the same thing. But keep in mind, I'd like to understand a little better sort of whether you only put non-diversifiable risk into the discount, how you divided the risk between the cash flows and the discount rate. I was a little bit unclear on that yesterday. So I just want to make sure if we're applying a WACC, we're applying a WACC. So that'd be great. Thank you. Is it?
All right. Thank you.
I mean, experts for the.
If we could please go to the next slide. So I understand that respondent's position is that claimant is not entitled to damages because respondent did not breach the treaty. So in that case, damages would be zero. I was also instructed to calculate the amount that claimant had invested in the property, which I calculated as 20 million. And it is only the direct and justified investment as opposed to claimant's experts calculation. If we could go to the next slide. In my view, the project remained too speculative for the DCF to be utilized. So investors, when they're valuing mining companies, they refer to the Canadian Institute of Mining through its Special Committee on Valuation Mineral Properties, SIMPL. And they have very specific standards on how you should value mines depending on the stage of development that they're in. And since this mine was only in exploration part of development, then the DCF should not be applied. It should be a cost approach, or it could also be comparable mineral properties. So as of the valuation date, claimant had not established any reserves and had not completed any feasibility studies. And respondent technical experts notes that annual production would be limited by constraints and that capital needs are significantly higher. More importantly, the claimant had not obtained a social license to operate the mine, which is critical. It means that the communities surrounding the mine accept the development of the mine, and that if you don't have a social license to operate, you can have significant delays, or you might have to invest more in the mine. So even if we go to the assumption that you should apply a DCF, there's still several hurdles that you need to get over to get to claimant's valuation, which I think is overestimated significantly. So first, based on respondents' technical experts, there were significant production constraints due to energy constraints. So based on that, the claimant's valuation would go down by 90% on a standalone basis. Moreover, claimant's expert has used a price that is overestimated. In fact, as I showed during my direct, there is a model that claimant used as part of the normal course of business that assumed a lower price point for the resource. Then claimant's estimate for capital and operating cost is also overstated. It should be about 20% higher. And in the economic feasibility studies, the range that you typically go of uncertainty in those is 50%. They're preliminary. And then as you make further economic studies, you get greater accuracy. So for the reasons that I mentioned before, the no social license to operate, no permitting obtained yet, underestimating the pre-operating risk, this property, if I were valuing it using a DCF, I would view it as a venture capital investment, and venture capital firms typically use a 30% discount rate for their DCFs. And if that's the case, the valuation on a standalone basis would be 85% lower. But if you take into account the other adjustments that I mentioned, then the valuation would be zero. Now, claimant's expert has also presented a relative market valuation. If we can go to the next slide, please. And the companies that claimant's expert selected are just not comparable to the mine in question in this case, due to the permitting status, the stage of development, the economics of the mine, or the type of resources, and finally location. So in my view, they're just not comparable, and the tribunal should not rely on it.
Okay. Thank you. Now, could I ask people to switch sides so that I have both experts here and both counsel there, so I can talk to the experts together. Thank you. So thanks for that. It's helpful always to be reminded of the facts after a night off. So I appreciate that. Those were both very helpful. So again, you were both careful to say that you were acting based upon the assumptions that you had given by counsel. It's a legal case. Counsel will give you assumptions to base your report on. I know that you guys did. I mean, I asked you to. You presented a very nice chart of where your differences were. Were your differences primarily based upon the different assumptions you were given by counsel? Could I ask Carla to answer first, and then if I could ask Isabel to help me out?
Well, the first difference is related to the permitting, the environmental permitting that is pending, that I assume that it should have been granted. So in that aspect, that is the first difference that we have, and which drives the start of the differences. Then other of the points raised by respondent experts are more related to the evaluation and how I already assessed for those risks, like, for example, social or pre-operational risk in my evaluation versus how the other experts propose to include them in the evaluation. But the first difference relates to if the permit should have been granted or not. Once we pass that issue, we have some difference on the evaluation.
Ms. Kunsman?
I would add a third category to that, which is that we've relied on technical expert reports that come to very different conclusions.
But before you even get there, right? I mean, to get to the to get to whether or not you should be applying a cost-based methodology or discounted cash flow or another methodology which is based upon the future earnings of the asset, it seems to me that fundamental difference, why is there that fundamental difference? That you're saying the correct valuation method based upon your independent expertise is to apply a discount cash flow method, and you're saying, no, in this case, it's investment and not even all of the investment. What is the core reason for that fundamental difference in methodology?
So in my position, any project will have value for the cash flow that is expected to generate. So any evaluation should be forward-looking. In this case, I use as the base the discounted cash flow, which is also confirmed by market multiples, by relative and comparable transactions. Regarding Symbol mentioned that once you are in a mineral property that you have resources, you could use the DCF when you have information, as I have in this case, or also market multiples. Symbol also mentioned to use cost, but in my position, that always fails to reflect what is the value of a project, because that value derived from the expected cash flows, not the historical ones.
Ms. Kunsman?
In my view, my valuation is based on putting on a hypothetical buyer and hypothetical seller. And in mining investments, they will rely on Symbol as well. And as of the date of the valuation, the resources had not been assessed. So in that case, Symbol, it is very clear that you should only use the cost approach. It was just an exploration properties. And then also, as per the technical expert report, it should also be considered an exploration property because of all the technical issues he mentioned. So in this case, there's no question that a hypothetical buyer and seller would have relied on the cost approach.
I'm having a hard time getting my mind around that. I mean, because that has to assume, so this is an asset. There's either, so they would have to be valuing the underlying mining as being essentially zero zero chances of success to say that they would apply a cost-based scenario. I mean, either they would say we don't want this because it's worthless, or they would apply something that looked, because I'm just focusing on fair market value. I understand that you might be saying in this case, fair market value isn't the right standard, but if we agree that's the right standard, then I'm just struggling with a hypothetical buyer and a hypothetical seller, even applying the DCF. It seems to me that they would end up with a valuation of something. I mean, the chances that there are reserves are not zero, right?
There could be, well, the chances that there are no reserves could be zero, because a mine could fail and become a complete loss at many stages pre-production. You could have resources in there, but you don't have the technology that you need to extract those resources economically. You could have the price of that mineral be at a certain level that because of your fixed cost of that mine, you're not going to be able to produce enough revenue to cover those costs. You could have a local community blocking access to the mine and delay your mine, by your works of either development or operating the mine by a year. Mine investments fail all the time, and one way that the mining industry works is that you get the minor mining operators take that risk, and then eventually they sell it to the majors once all those risks have been taken into account. So,
yeah, I mean, I understand that there is a risk of zero, but you have to be saying the risk of zero is huge to say this has no value to a hypothetical willing buyer and hypothetical willing seller.
And according to simple standards, that is a huge risk, and that's why they recommend
30% discount rate.
Well, Symbol recommends just using the cost approach. But if you were going to use a DCF, which I don't think should be applied in this case, I would say then you would need to value it as a venture capital, and then you would have a 30% discount rate.
If I can comment on something first. My understanding is that this is actually a mineral property because it already have the resources certified, not reserves, but resources. Symbol in that case is proposed to use the market multiples. As I showed, that validates the DCF. And in certain cases, the DCF for cost. It's not that cost is the only method that Symbol recommends. And Symbol always, even in exploration properties, recommends a market multiple. Because at the end, if you want to do a willing transaction, whatever transaction you have in the market is the best indicator. Probably there are not perfect comparables, but it's the best direct indicator that we have. And as my colleague was saying, there are a lot of risk in a project. That's why when I do my evaluation, I only account for a percentage of that resources that are going to be produced, and I don't discount the expected cash flows at the risk-free rate. That will be the case if I expect the project to go perfectly by the base case. So I'm already penalizing the valuation for those risks, and also for this for the additional costs. There are costs related to social programs in the operating cost, and also the discount rate reflects the risk or the cost of capital of pre-operational projects. So in that way, instead of doing 100% of the resources discounted at the risk-free, that is not what we are claiming is the value of the project, but we are already penalizing it through the production, through the discount rate, and also via the cost to include the relevant costs that were assessed at the time.
So, counsel, I'm going to turn it over to you to talk about risk, but I also want to warn you because, as is always the case in these hot tubbing, a lot of it comes down to fundamentally legal issues. So what I'd like you to do after you ask some questions so what we agreed yesterday was, since you guys didn't get to finish your questions on risk, you all would take the lead on risk and I'll mop up. And if you have any questions on these subjects, please feel free. And then if I'd ask you to go ahead and finish up on risk, given the very limited time before your flights, keep it snappy. And then the other thing I'd like to say at the end, I'd really like to have you give me just a quick snapshot view of what you think as counsel. I mean, the technical experts aren't here, but as counsel, is there a hurdle for me to apply a DCF in this case? In other words, do I have to be, there are those who say that there has to be past cash flows, assuming that's not the standard, but is there some standard I need to apply? For example, do I have to believe that it's more likely than not this mine would have reached production stage before I apply a DCF? Or is it because it's fair market value, it's just fair market value, so I do what the market would do regardless of any sort of legal hurdle? This whole debate over, is it too speculative, but we have to take account of risk. So that's what I'd also like you all to talk about, and whether, the very different assumptions here, which I think have impacted the experts' testimony, both oral and written, a lot. So if you guys want to ask some questions on risk and any questions on this, and then I'll take over again. So
Certainly.
Just a segue, we wanted to give you a little idea of how it would look if counsel led versus the arbitrator. So now counsel's going to lead.
Good morning, Ms. Kunsman.
Good morning.
Thank you for your presentation earlier today. Actually, if we could put up one of your slides, I'd like to go through some of the comments that you made. So if we can go to your first slide, which I think is number 9 in the deck. I'm sorry, I know I'm putting you on the spot here with doing that. I was interested in your comment that you said venture capitalists would apply a 30% discount if they were viewing this project. Are you a venture capitalist, Ms. Kunsman?
I am not a venture capitalist, and I am not saying that venture capitalists would use 30% if they viewed this project. A venture capitalist would probably not be the investor that would typically evaluate this type of projects. It would be the majors or other miners that would evaluate these projects. And in my view, they wouldn't get to a DCF. They would simply stop at the cost approach.
And do you work for a major mining company?
I have been evaluating mining companies for over 20 years now, and I am part of the energy and process industries practice at Alix Partners. And we advise both majors and miners in all types of mining questions, from operations to investments, due diligence. And then also, of course, through my education as an MBA, I was specifically trained to be able to value all types of investments.
Well, could you answer my question, which is, do you work for a mining company?
Well, right now I am engaged by different mining companies on different projects as a consultant or as an expert witness.
And have you ever worked on selling a mine to a major mining company before?
I have been advising teams that do that, yes.
But you yourself don't do that directly. You're not in that business.
No, I'm in the business. I'm an expert witness, yeah.
Okay, now let's go through the risks that you've identified. You haven't conducted a DCF model yourself, correct?
I have.
You have?
Yes.
And in your view, the assumptions in that model would result in you going down to a value of 0. That's the takeaway from your presentation.
Yeah, it depends whether you take them on a standalone basis or together.
Can I just ask a question? Did you share your model with Ms. Kunsman, or was this, did you use?
Correct. Yes.
That's what I assumed.
Yeah, we both agreed on the basics, and we were just changing different assumptions.
Yeah.
Now, what was interesting to me is that, you said that there are so many issues that get towards production, right? And that's why sometimes mines fail. They don't get into development. At issue here, though, is the government denied the permit, which was a major reason why this mine hasn't moved forward. That's not an assumption. That's factually the government denied the permit that's prevented this mining company from proceeding forward, correct?
I can't answer that question. That's a legal question, and I believe that's what's at issue in this arbitration. And what the tribunal needs to decide.
Okay, so that's an assumption that this mine has not gone forward to production because the government denied the permit. That's an assumption that you've been given, correct?
I've been given an assumption that the government did not breach the treaty, and also there are many other reasons why this mine could fail.
And one of the things that you said during your presentation was that it's too speculative. Those were your words, right? This project to go forward, it was too speculative. You're aware that there was a preliminary economic assessment done of the mine, correct?
I'm not sure I said the word speculative. Could you point to me in the transcript where I said that, please?
Well, actually, let's just debate this then. Do you think it is speculative that the mine would go forward? Because we don't. That's the claimant's position. What's your view?
My view is that as putting myself in the shoes of both the hypothetical buyer and the hypothetical seller, I would fall to the industry standards of symbol, and I would see that based on the technical reports that I've been provided, this property falls under an exploration property category. So I would use the standard that symbol suggests, and that would be cost approach.
And
Or market, right? It's cost. or
You're
market.
absolutely right. Cost or market, yeah.
so if you were a willing buyer, surely you would look at the preliminary economic assessment that was done, correct?
Yeah, but that preliminary economic assessment was done not at the time of breach. So at the valuation date, if I were an investor, I couldn't look at that.
Well, sure, but you're an expert, so you're able to take that preliminary work that's done at a different date and move it and adjust the variables accordingly for the data valuation. That is what you do for a living, correct?
Yeah, and when we value, we either use the ex ante or the ex post approach, and you should not mix the two. So if you're going to do ex ante, you should rely on the information available as of the time of the valuation. And as of the time of the valuation, there wasn't an economic feasibility study done.
Right, and do you know that the mining company...
I just want to understand the facts. It had been done, right? It had been done.
As of the date of the...
Yeah, the preliminary economic assessment was done before the date of valuation. As of the date of valuation, they were working on a feasibility study.
Right.
Just to comment, the preliminary economic assessment was done at historical prices before the date of valuation, which were lower than the ones of the date of valuation.
And Ms. Chavich,
were you asking me about the feasibility or preliminary economic study?
I was asking about the preliminary study. The reason that there wasn't a feasibility study done was because the permit was denied. Do you know that?
Yeah. That is a legal issue that I don't know the details of it.
And did you know that the claimant was in the process of conducting that feasibility study when the government breached the treaty by denying the permit?
I understand they were, but it wasn't done. So as an investor, they couldn't rely on it.
So we are faulting the claimant for not being able to complete the feasibility study that you seem to need, even though the government's actions prevented the claimant from completing the feasibility study. Is that the position?
No, I'm not assigning any fault. I'm just looking at the documents that a hypothetical buyer and seller would look at. And at the time of the breach, that document was not available. A feasibility study was not available. Why or why not? I don't get into those.
You're blind to the why and the why not. Well, lucky you. Okay, I would like to go to your last slide, please, where you look at, you comment on the market approach adopted by this expert, by Ms. Chavich. Now, you have several critiques here, right? Some of your critiques are that these are not comparable transactions, in part, and there are various reasons that are listed here. For example, permits granted, reserves, etc. Did you look for any comparable projects yourself?
I did, and I spent a section in my report where I narrowed down a list that started with about 100 properties, then to 10 that had some hopes of being comparable, and then I ended up not finding any.
Could I ask you a question just for my edification? But you could make it, could you make adjustments to the comparables that you found and that the claimant's expert found in order to make them more comparable? Or did you feel like they were, because I didn't see that in your report.
Right. I mean, so for a lot of them, I knew the adjustments that I would have made, but unfortunately, the information was not available. So
Thank you. I do think we need to keep track of time.
So I'm in your hands, Madam President. You asked a series of questions of us. Would you like me to answer the questions now or wait until...
We let
Sure.
respondents counsel ask any questions he has on the risk or any of the things I asked. Please.
Thank you, Madam President, and thank you for the presentations. Ms. Chavich, I have some... Hello? Yeah, okay.
Perfect.
So, thank you, Madam President. Ms. Chavich, is that correct? Yes. Thank you for your presentation. In your examination just now by Madam President, you mentioned, among others, that your opinion is that any valuation should be forward-looking. Is that what you just said?
Yes.
Yes. And would you also agree that in order to apply DCF method, certain criteria should be fulfilled?
To apply a DCF, you have to have information to apply the DCF. I think that what is relevant when you apply the DCF is to account for the cost and risk that are relevant for the evaluation you are doing, but you can apply the method.
But would you agree that the most common scenario, and I think you also mentioned that it's a generally accepted approach, the DCF, and the most common scenario is a going concern with a track record of profitability?
I think that you just need a going concern. Otherwise, a startup wouldn't have any value. So the program record facilitates the evaluation because it gives you some anchor of some information. But in reality, what is important is the going forward part. You want to forecast how this asset or any asset is going to perform. So I will disagree that you need to have an historical record.
But would you agree that one needs some reasonable certainty of future, that there would be any future income in order to apply DCF method?
You have to expect to have a forecast of income. Otherwise, the property value will be zero if it's not going to generate any cash flow. So you have to have expectation of having positive cash flows. But as I said, when the logic of the discounted cash flow and why we discount that cash flows is just to show that, yes, you can do what was the cash flows that were expected, but you can also get higher cash flows and also lower cash flows. And that is why we discount the cash flow to assess for that risk.
But you also build risk into the cash flows, right?
Yes, true, via the cash flows and also via the cost in a sense. Because at the end, most of the risk can be allocated or in a sense adjusted by cost. So if we talk about pre-operational risk, we have an investment, and that investment has certain cost buffers in case those capex go higher to have that risk, right? So we build up certain contingencies to account for the risk. In mining, you can also have social risk. So that's why the costs include social programs, schooling, education, and health, and PR with that communities. So yes, you have it via the cash flows. Also, you can do a scenario analysis and account for certain delays that can happen. But you have it both, and especially you have it in the discount rate. And by having not only the time value of money, but a higher discount rate to reflect those risks.
But do you put do you differentiate in your model between diversifiable risk and non-diversifiable risk in terms of what you put into your cash flows versus your discount rate?
Unfortunately, not always the information is as clear to do it, but mostly of what is non-diversifiable is in the discount rate. But we also have to account in the discount rate for the particularities of this mining project in particular, a pre-operational. So if you are an investor that invests in several mines, you could diversify away that pre-operational risk. But in this case, I'm not assuming that you can diversify that risk. I am accounting for that risk in my discount rate.
But not, okay, I understand. So I think there would be a discussion as to whether that should go into the cash flows and discount rate if you can't diversify it. Ms. Kunsman, what's your view on that?
my view is that there's not enough of the risk accounted for in the cash flows nor on the discount rate. I could point out specifically where in the discount rate, or it's also pointed out on section 5 of my report in great detail. But there's a very small country risk premium, but there isn't any project-specific risk premium on the
I think there's
discount rate.
5% on for some.
You did?
No, what we have, but our discount rate, my discount rate is based on the cost of capital of other mining and pre-operational mining projects. So it accounts for the normal risk of pre-operational mining properties. The project specific is reflected by having the pre-operational mining risk plus the country risk that I defer that is small. We are assuming a full exposure of country risk when this is going to be fully exported, and there were certain taxation is clear and is already set in the concession contract. So in that sense, I wouldn't call it to low the country risk. Then the specific risks that could happen between the capex or the cost are accounted in the cash flows, as we mentioned before.
So
Please.
So, for example, as I mentioned before, the accuracy of the cost projections in a pre-feasibility study or different types of studies go down in time, right? So what I see in the model is that the cost could be underestimated by as much as 50%.
And that's in your adjustments.
And that is in my adjustments. I don't see that in her adjustments specific to this project. And then other risks that are specific to this project, not to projects in general.
Thank you. Did you have a last point on that? I see from your body language you might.
Well, regarding the costs were also validated by a technical expert, even if they were pre-economic, based on the preliminary economic assessment. They were validated by the technical expert, and I also benchmarked it with other projects that are operating. So I think that those costs cover that. And then regarding other particular risk of this project, again, all mining projects have risk, and that's why basing the information on other pre-operational mining projects, take into account what will be the normal risk that these companies or these projects are exposed to. In this case, we have the permitting that it didn't come through, but that is what we are discussing about
today. Yeah.
Right, but if can I get a chance?
Yeah, please go ahead.
To that
Last point. The subject.
Of course, it wasn't just the permitting that they needed to get. There were other issues as well, and there's also a respondent expert that has also testified that those costs were underestimated. And as I pointed out in my report, that claimant's valuation implies an IRR of 35%. So that is, you need to take that into account, not just...
Thank you. So what I'd like to do to give a chance to have a discussion of the broader issues is maybe if you could just give me each a very brief... So my fundamental question in this case is there are many detailed questions, but in terms of whether I should be looking at the discounted cash flow value, I'd like to understand and I will be obviously asking post-hearing questions and you'll get more of a chance, but just in terms of my thinking over the period before I get those answers, is your view that there is, whether, I don't want to call it too speculative, but whether there's any hurdle, do I have to be reasonably certain that this project would have been profitable at all before I apply the DCF method or would apply the DCF method? Or is it just to look to what would be fair market value in general, which, an investor may or may not actually look at whether there would be reasonable certainty or not? Is there some legal hurdle? There are cases that say yes, there are cases that say no, there are cases that say DCF is inherently too speculative. So if you could just give me a really brief on that, and then we'll go to the audience. Thank you.
Sure. Thank you, Madam President. First, the standard that the claimant seeks here is application of fair market value. And fair market value in this instance requires application of the income approach, which is essentially using the discount cash flow method that's been put forward by claimants experts. I want to dispel this notion of too speculative. All mining projects have risks. That is correct. And here, all of that risk commercially was borne by the claimant, right? The claimant, this entrepreneurial junior exploration company, went to do exploration work, to do drilling, and to uncover essentially millions and millions of metal deposits under the ground, right? And they went out and spent $50 million of their own money, bearing all of that risk commercially and technically, to discover that there was a deposit in which there were 700 million tons or 4.6 grams per ton mineral, which could be exploited over a 10-year period. Now, here's what's happened. Having made that finding, the government has decided to deny the permit and prevent this project from going forward, leaving this claimant who has spent $50 million of their own money to uncover a world-class project, that it was in the process of going on to a feasibility study to complete, that it was going to be able to finance and perhaps even sell to a big major company, as respondents experts suggested could happen. That's typically what is done. And that's why now here they need to be rewarded for the risk that they incurred. The tribunal should find that respondents breached the treaty when it denied the permit. And this is the major issue that's coming up here. Why is this so speculative? It's speculative because we've not been able to move on to developing the project. Why? Because of the government's denial of the permit. When you look at all of the cases in which pre-production mining claimants have received lost profits, for example, Crystal X versus Venezuela, in which the tribunal awarded over $1 billion in damages. Rockhopper versus Italy, in which the tribunal awarded over 200 million euros in damages. Those are cases that were at the pre-production stage. And the reason they had not moved on to development and production was because of the government's breach in those cases. Similarly here, the claimant has not been able to move forward because of the government's breach. That doesn't mean that the project would not have been able to be done had the government not acted unlawfully. And that's the hurdle for you, right? Once you make a finding that the government breached the treaty when it denied the permit, the claimant's experts have put forward all of the data to show that this project was bankable, that it would have been financed, that there was resources at the measured and inferred level that could be extracted from the ground, and it was technically feasible to do so, and it was economically feasible to do so, and it would have been done over the life of the mine for 10 years. And therefore, the value of that project, as claimant's expert has put forward, is $650 million. The claimant's expert has gone above this task of just using the income approach, but also corroborated that income approach using the market approach, which is also endorsed under SimVal, correct? And there, conservatively, she found that looking at comparable projects, that the value of damages would be around 735 million. So you can see here, you don't have to rely on just the DCF. You're seeing a corroboration by looking at comparable projects that have been standardized to essentially award damages to the claimant in the amount of 650 million.
Thank you, Mr. Rauschning.
Thank you, Madam President. So first of all, to answer your question, Madam President.
Thank you. I'd love you to. No one has so far.
The question of what standard should be applied. I think it's important to distinguish between two levels. The first one is whether there is whether the claimant has managed to establish any case for damages at all. So whether there would have been income. If they have established that, then it's a question of how to value that. But if they do not manage to meet this first part, that there will be that this project would have actually gone forward. And respondent's expert, Ms. Kunsman, has pointed out a number of issues, not only the license to which claimant tries to narrow down this issue. There were many other risks that this project was facing. So it's already unclear whether there would have been any income. But even if Madam President should conclude that this hurdle would be taken, then it would still be necessary to establish that in order to apply the income approach or the DCF approach as argued by claimant, that these cash flows would be sufficiently certain in order to apply that. And we've seen the data from Ms. Kunsman. But just by changing a single parameter of the DCF calculation, damages change by 90%. Other changes result in 85%. So this is highly speculative, the amounts we are reaching. And while claimant is referring to the market approach, we've also seen that those companies, which is a common problem of applying the market approach, it is hardly ever possible to really identify a comparable company or comparable transaction, especially in such a particular case as involving early stage projects, where it's very, very important. We've seen that also on the figures on the slide. Depending on the stage of development, values are hugely different. So of course, local characteristics about community support or lack thereof. So all of that impacts the assessment. And the cost approach, which respondent considers is the right one, is also consistent with a fair market approach, because it would be the question a willing buyer and willing seller would consider whether if there's actually no sufficient certainty of cash flows, then a willing buyer would only be willing to pay a reasonable amount of investment, an amount which it would need to invest for a similar project. Otherwise, it would spend its money elsewhere. So, thank you.
Thank you both. My fundamental question in this case is whether, it's not whether it's overly speculative. Investment in mining is inherently speculative. And we're applying a fair market value standard here. So the question in my mind is, when you're applying that standard in this type of case, whether before you apply discounted cash flow analysis, there is a sort of separate test as to whether I'm convinced more likely than not this would have reached a level whether it's more likely than not, whatever the legal standard is, that this would have reached a level of profitability, or whether I just look at fair market value. But we can leave that for post-hearing briefing. You've all been incredibly helpful. I particularly want to thank Carla and her firm for the fantastic scenario that they developed. I'd like to say again that nothing we've said so far reflects how we run a hearing, what we think on these issues, what our firms think, any of that. It was just, so the purpose of this exercise for this session was to try and think about whether a tribunal-driven quantification stage, not damages stage. So assuming that you've already, you've proven that there was a breach, the damages occurred, they were foreseeable, whatever standards are being applied. Once you've done that, and you're really getting into the quantification of the numbers, where almost every jurisdiction says there's a margin of maneuver, whatever, we have more flexibility as arbitrators, because the quantification of damages is inherently an art rather than a science, particularly with future profit earning exercises. So what do you all think? Do we think that based upon this scenario, it's more or less useful to have the tribunal drive the questioning like we did in the beginning, or counsel? And maybe I'll ask the experts first, and then anybody in the audience, I'd love to have your views.
So I obviously like that the tribunal take a role and pay attention to quantum. Probably a little bit of that is ego, feeling that someone that I did matter. But I also think that that is a useful tool for the tribunal when you have to write the award, having all the questions and the assumptions that you need to put in that award already answered by the experts. And also providing, if needed, another sensitivity or another assumption that was not presented by any of the parties. That being said, I also believe that having the cross before is useful, especially for the parties to show their case. But after that, having, or during that, and after also having a tribunal that has been paying attention and prepare on damages and asking questions. I found that useful, and I think that it reflects after in the award, because otherwise there will be questions that the tribunal will have when preparing the award, that maybe they didn't make the question to the experts and then don't have the answer to those points before. So, yeah, I will agree with the motion in this case.
And Kathleen, you might not be able to see, but 85% of people think you're a better, more productive examiner than Sim and I are, and advocate.
But some of them are my students.
Approach.
You know, I don't know how you voted, so.
Not yours.
Oh, so Isabel said something to me at dinner last night, which was, yeah, but when the tribunal gets into too much nitty gritty, and sometimes, you're a sole expert because either the respondent is not appearing, or the respondent hasn't presented an expert, or has presented a really bad expert, like what happened in P&ID, for example. You're kind of the sole expert in a way. And then, someone like me wants to get into the nitty gritty of the discount rate. You're like, what? Whatever. So what's your view of having I'm paraphrasing, of course, to me's dinner, but,
Right. So my experience is that by the time you get to the hearing, the differences between the damages amounts are very clear. And it's not just putting down the different adjustments to the model, but having a third column that says, it is a legal issue, it is a fact issue, or an assumption from another technical expert or whatever. So there are very few issues that need to be handled in my view. But like Carla said, it is very helpful when the tribunals, after you've done your direct or even the cross, they'll interrupt and say, okay, I'm still not clear on this issue. And that's very helpful. And actually, now that we're back to live, it's also helpful to have the tribunal in front of you and read the tribunal. That was sometimes two members will talk to each other, and you're like, okay, they're not getting something, let me do it again. So
yeah.
So you are a professor in a way. Now, what our work, I know we presented in a few slides or in a very tight report. There's so much data behind that, and so many models, and sometimes even the question from the tribunal that they're asking, we don't even have a model for that because we're not taking it into account. So it's not as easy as having a conversation on the stand when there isn't someone on the other side. And in trying to be fair for one side not having an expert, you're being unfair to the side that actually has an expert, because the tribunal then has the final word, right? You don't have...
But not necessarily, right? Because let's assume I'm the arbitrator. I have to decide my view as to what the appropriate quantum of damages is in this case, based upon the evidence I've been presented. But if you look at P&ID, for example, that's where the arbitrators just said, they presented an expert report, they didn't. We're basically going to give Nigeria however many billions with very little basis in the expert report because there was one presented. So I think it's always, I feel like we have to be convinced that the claimant has met its burden of proof on the specific. I mean, we have to quantify it, right? Even if the respondent hasn't presented a damages report, or vice versa.
Right, and in that case, to me, it would seem more productive to then have the tribunal in advance of the hearing ask very specific questions, so then the expert can really have time to develop them, not just during the hearing.
So I want to ask counsel in the room here and maybe in the audience, because I had a very interesting experience. I did a damages panel in New York one time. Actually, I know, 5 years ago, almost to the day. And a friend of mine, who was my colleague at the time at White & Case, she was saying, actually had been my colleague at White & Case, said to me, she's like, yes, I'm all for, robust, tribunal-driven, yada, yada. And then she said, now that I really think about it, I always have a feeling like if they get in too early, but I know my case, you don't know my case, what do you do? So you believe theoretically you want this, but not necessarily in practice. So I don't know, what's y'all's view of a hot bench? Viren, Tim?
Yeah. No, so I think an active bench, especially if it's an active bench, so well familiar with damage issues like this one, is good. But I think, as you rightly point out, it's an important question when to intervene, when to have this bench. And I'm not sure, as in many cases, there is a one-fits-all answer. So I think if you as an arbitrator have the impression that the experts and parties are very far apart or address issues which are, in your view, not relevant, then it may be better approach to intervene earlier and steer in order not also to waste too much time at the hearing on issues which may not be relevant. But of course, nonetheless, give counsel the opportunity to present those cases and convince you that they are nonetheless relevant. But if it's a different situation where parties are closer together, then intervening at a later stage may be a better approach. That's at least my view.
Sure. I agree with all that's been said. I think as counsel, we want the tribunal to be engaged, right? We want to persuade them. We want to see them being actively involved, whether they choose to ask questions of counsel or they choose to, ask questions directly to the experts. To me, that's all very positive because it shows that they're addressing the issues at heart. I think that the challenge is, as counsel, you've also lived with the experts and their reports for years. You know what went into the report, what did not go into the report. As much as tribunals are prepared, counsel still believe, correctly or wrongly, that they know the case better than the tribunal by virtue of having seen the behind-the-scenes stuff leading to that hearing. And so my only comment would say I'm all for inquisitorial tribunals and hot tubbing, etc., but to make sure we keep sufficient time for counsel to get to do their job too.
Absolutely. So what I think as an arbitrator is that, and you all sort of assumed, I think, because of the way you work, that there would have been exchange between the experts before, right? So if you look, there's also in the handout a chart that says position, and usually there'd be a third column that would say the basis for the difference. So then when I go into the hearing as the arbitrator, I know this was the one side's position, this was the other side's position, and this was the basis for the difference. Now, some arbitrators don't require that, and arbitrator and experts who are not as used to this sort of collaborative approach. The thing is, these are primarily investor state people, and we are used to these very sophisticated forward-looking damages analyses. Sometimes it's not that way, and then you have experts who may not be used to collaborating. I think wrongly say, sort of the U.S. experts who are such, sharks or whatever. My experience, they can be anywhere. It's a question of whether they're willing to collaborate and really consider themselves to be the tribunal's experts and are trying to help me as opposed to, but I do think that sometimes that's better to set the stage early. So from the first CMC, even in a commercial case, are there going to be damage experts? How can we, are you willing to interact? Do you want counsel there? How would you like, because if not, everything goes along and it's, a month before the hearing and we're saying, oh, can you guys talk to each other and tell me what the issues are? Anybody from the audience willing to raise their hand? Counsel, arbitrators, experts, anyone? Okay, we can talk forever, so.
I will say that, I do want to make sure counsel is involved when the tribunal is doing whatever they're doing. When Carla was separated from me, I was like, why is she going to sit over there? She's, my expert on my side. So I would say that when the tribunal sort of alienates counsel, I'm not a fan of that.
But if you're going to hot tub, the experts have to be next to each other.
Sure.
Yeah. So it makes the whole thing. I mean, that's the thing. Your counsel, it makes you nervous. I actually don't have the app up. So if there's any questions on the app, Louise, can you check? Okay.
Joey.
Yeah, if you could show them. I'm sorry. It's my bad. So we have about 8 more minutes if we stay to time. So.
Daniel with this. I can edit it.
Open. Okay.
I can let's on.
So So we have some interesting questions. First, concerning Barry, do you want to ask your question live?
Sure. My question is, this is very, very helpful. I spend my life dealing with investor states, so technically, I found this very useful. And somebody who spends my time doing this all the time. I've never actually seen an interactive session like this, and so I really have to thank the moderator, the arbitrator, and the participants who really added a lot. My question is about something different. It's not working both three right now. Is actually proposing putting in rules for investors for arbitration on damages. And these rules would in fact change some foundational things. One of the things they're proposing potentially is to prohibit the use of DCF. Another thing they're proposing is to prohibit the use of compound interest to only apply simple interest. This is from the current cross-cutting issues paper that they issued recently. I'm just wondering, to the extent that we have such a good panel here, how will these external factors impact your ability to do your job? That interests from an arbitrator's perspective, counsel's perspective, and expert's perspective.
So you can't do it. Thoughts?
Sure. I think those initiatives at Untitral are a little bit dangerous, to be honest with you, because foundationally, the tribunal and the standard that it must apply comes from the treaty, the underlying treaty or the underlying investment contract, right? So whatever is contained in the treaty or in the investment contract regarding fair market value or the standard of compensation or full reparation or the interest rate or whether it should be compound or not, should be drafted and put into at this stage. The stuff that exists then in a vacuum coming out of Untitral that says, as a matter of principle, or we recommend, that we should be using simple interest rather than compound interest. I think that's difficult to do because you're not tethered to the actual text from which you derive tribunal, your source of authority, but also the legal standard that has to be applied by the tribunal.
From the expert perspective is, if the treaty says fair market value, and you can use a DCF, then your valuation is not going to be fair market value. It's one or the other. And in terms of compound or simple interest, it depends on the language of the tribunal, of the treaty, which sometimes is very vague. But if I've done all types, but it's always based on some legal instruction in a way, or either from the treaty or because of the domestic law.
Carla?
No, I shouldn't say this, but probably they should have some economist person opining, right? Because the two things or the two limitations that you pointed out goes against any economic from a finance or business or market person. So, and in general, having rules that it tells an expert how to do things that are logic, like using a DCF, as Isabel was saying, or compound interest. I obviously it would affect my work because it will limit it, but it will really drive it. I will be doing something that goes against all my economic and financial knowledge in this particular example. So I prefer to leave that decisions to the experts as the legal decisions to counsel.
So my own view is that you cannot, and this is, Untitled 3 work on this subject we can talk about for a whole other session, and I don't know where they're going to end up, but UNCTAD's got some worse things out there, so watch this space. The point is, and I think it's a point that you all are making, Tim, I don't know if you cannot say that you're applying a fair market value standard and then say you are prohibited from applying the DCF method to determine that, unless you don't believe the fundamental proposition, which is that a willing buyer and a willing seller are willing to buy an asset based upon its future cash flows, which again have to reflect all kinds of risk, discounted to the present value, again discounted to affect all kinds of risks. That valuation may be negative at the end of the day, But it is, if you don't believe that, then maybe you could get to where Untitled is. But since every economist I know, and I know many, would say that's wacky tobacco, that doesn't work. So the point is how, and this was a government, I mean, the whole Untitled process has been less than ideal. So let's see what happens at the end of the day. But as I said, UNCTAD has some more controversial language out there. So we should all be watching this space. Do I think arbitrators will follow it? No. I don't think arbitrators, on the whole, will be convinced that they can apply a fair market value standard without looking to the future profitability of the asset. But there's a lot of things in there that are more nuanced that could have an adverse impact. So go ahead.
Yeah, well, I think as also Viren said, it will be very important how this is actually then tied in with legal text. Is there going to be references in treaties to that? Then, of course,
that's different. I'm talking about on today's treaties.
Then you cannot ignore it, even if it's doesn't make sense. I mean, states in the end are the masters of the treaty. But also the interest part, especially considering how long collection of awards nowadays take, is of course a dangerous change.
Yeah. So we have just a minute or two more. So I'd like to ask one question because it relates to what we were talking about, and I think it is the risk of this very hot bench. What happens when a tribunal goes too far and creates new issues or arguments that counsel did not make? Yeah. Maybe because they were unprepared. I don't know what that means. But anyway, so what if I think, wow, there's an issue here that wasn't picked up. And does that make a difference whether it's on quantification or whether it's on the law? I mean, what is your view about tribunals adding new issues? I know what your views are going to be.
Yes, omitting the part of unprepared. So let's assume it's an issue that is related and relevant for the case. I think that in that situation, and I have some cases in which that happened, probably if it's related to quantum, the tribunal can get back with a list of new instructions or requirements that the experts can agree or how to implement in their model or not, like a joint model plus, in a sense, in which you have those additional issues. But it can be challenging in a sense, like, I have a case in which the tribunal asked to do a scenario with no expansion because both experts had different expansion plans. So we agree on that, and it's something that could be implemented in the model. You have to adjust maybe CapEx, but it's something that is straightforward. Then if you open the discussion of something, date of valuation or permitting status, that could be more challenging and to get the agreement of the expert and implement it exposed. So I think that it depends on what it is, but again, we are at the service of the tribunal, and probably what we do as experts is then try to accommodate. Sometimes we will need to have more information in the record for that, and that can be also be challenging.
Yeah. Isabel? Having been in that situation, my reaction is always to look at counsel and say, well, is this procedurally acceptable, right? There's a procedure. What?
Too late.
Tell me the rules or intervene, please.
But usually if it's the tribunal asking,
Right. I get it. So what I try to do is in the direct presentation say something to the tribunal to say, if you have other questions about this or you'll need us to run additional models, we can.
Right, ask afterwards. The other really interesting point that we won't have time to get into, but someone asked about precedent. They asked, what if there was no other case that have ever awarded, based upon the future profitability of a mine at this stage? How would that impact the tribunal's reasoning? And it is interesting. Lucy Reed gave a talk in Germany that we were both at, and I think you were at, but anyway, I was at in Berlin. And she talked a little bit about, there's so much quoting of precedent now, particularly in investor state cases. And it's not, so the question is that a really appropriate helpful? Is that going to be persuasive? And the extent that it's persuasive. Every case is different. So the fact that no one's ever awarded damages based upon the future profitability of a mine at this state, I think would have limited impact on most arbitrators. They would say, well, we're not interested in those cases. We're interested in this case. But it would be in the back of their mind, I think. So I think there's, so that I thought that was an interesting question. So it leaves me to thank you all and to thank my experts and to thank my counsel and particularly to thank Carla for the great scenario.
Yes.
So, and again, none of this represents anything we really think. Thank you very much.